Now 30% I believe is a big enough number for it to at least be considered on a case-by-case basis. So I'm going to go on with my argument. So some crimes are so gruesome that the death penalty should at least be allowed for consideration. I'm going to tell you the story of young J.P. Orlowitz, a babyface senior from Massachusetts. He's cute, is he? Kent High School senior Jean-Pierre Orlowitz ambushed 26-year-old Daniel Sorensen in a garage owned by Orlowitz's grandfather. Mr. Orlowitz lured him into the garage where they prepared a space to kill him. Sorensen was stabbed multiple times in the back, his head sawed off, and his body wrapped in tarp. Orlowitz burned his hands and feet with a blowtorch, most likely in an effort to conceal his identity. He made plans on how he was to clean up the blood, and he made plans on how he was to dispose of the body. He loaded the body in a pickup truck, dumped it in a cul-de-sac, and set it on fire using gasoline. Sorensen's head was later found in the Rouge River. One detective on the case said, and I quote, "We've seen it all. We've seen a lot, and still a crime like this surprises us. Anytime anyone kills just because they want to, and that's what the evidence here suggests, is bone-chilling. So why would anyone want to do that, especially being 17 years old? It makes us think and ask a lot of questions."
So clearly, like, this plan that you described, that he set out,
Yes.
it was very complex, right?
Yes.
So obviously that requires a certain level of maturity. So
Right.
clearly his level of maturity shows that he should be mature enough to accept the consequences of his actions, right?
Yes.
Just to jump off what Justice Jen said, you described the gruesome and terrible crime he committed.
Yeah.
Would you say that was premeditated? He ambushed him, he sawed off his head. Now, do you believe that this is a special case or something that you see every day, run-of-the-mill murder?
Well, it's certainly not something we see every day. This kid obviously had this planned, and it's notoriously known as the thrill kill. So it's something that doesn't happen every day. So that's why I'm saying that the death penalty should be considered in instances like this where there's a rationale behind it, yet he's killing for no reason at all, even though he planned everything out, but he doesn't have a legitimate revenge, or we need to take into account all these circumstances.
What is the background of Mr. Jean-Pierre?
Well, like, he's a high school senior from a upper middle class town, and he obviously has a fairly good education, as the school quality there is rated pretty high. And they say he killed him for the thrill of it. That's why it's notoriously known. I mean, there's a cold case episode about this killing right here, so.
There's no instances of abuse or family, abandonment, anything in his past?
I've read a lot, and I haven't seen anything about that.
Would you say that this case proves that sometimes, regardless of your background, someone can commit a crime and end up, should be held responsible for their actions because it's not always based on your background?
Exactly. In disturbing cases like this one, in all aspects of the case should be looked at, and if the death penalty should be applied, if the courts deem it the necessary means of punishment from what's been. Okay. So while judging if the death penalty should be applied, the court should take into account the recidivism rate for young individuals is very high. Statistics hold that 2/3 of all offenders arrested this year for violent crimes will have had at least one prior arrest, and 40% will have had at least 5 prior arrests. So the foundation of our judicial system is based on moral capability. So why change this to protect juvenile killers? The ultimate punishment is only imposed to those who intend to kill and are aware of the consequences of their actions. Yes?
Would you say that retribution is a tenet of the juvenile death penalty?
Would I say it's a tenet? I mean, it's
Would you say that it makes up the reasoning behind using it? Retribution, it makes up one of the reasons you would use the death penalty?
Well, like we said, we want to consider a totality of the facts, and retribution could be one of those factors considered in terms of the death.
Okay, and retribution is reserved for the worst of the worst. And juveniles are the most likely, according to statistics, 1/3 of them do commit, but 2/3 don't, which is a supermajority. So,
To commit what? You said
to commit 1/3 after the release commit another crime, but 2/3 don't, which is a supermajority of those rehabilitated, which shows that it's successful. So, the emotional immaturity and the lessened culpability and high rate of rehab, why is it that they deserve the death penalty then?
Well, you actually made this point clear for me because you said that 1/3 commit a crime after. So that's why we plan on exploring this on a case-by-case basis and seeing what the percentages are of them committing another heinous crime, like we said. So I'm going to pass the rest of my time to my colleague over here, Mark.
Counselor, if I may, before you start,
Yeah.
for the reference of the court, what was the sentence handed down for Mr. Orlowitz?
Yes, it was life in prison.
We start off with that 18 is just a number. It's a simple number. And you can't simplify one person in just one thing as a number. It takes more than just a number to determine how one is treated. Is our country so arbitrary and capricious that one is solely judged based on something as simple as a number? Now, in Gregg v. Georgia, they established a bifurcated trial system. This was so that's a system, as I'm sure you all know, as one trial for guilt and innocence and a separate trial for sentencing. So this was designed to eliminate being judged solely on one factor, aka a number. So the whole purpose of the bifurcated trial system is so that we don't just judge juveniles based on a number. All the factors have to be taken into account. The mitigating, aggravating circumstances. Also in Gregg v. Georgia, they established a proportionality doctrine. And as we see by G. Pierre Orlowitz, this is definitely a proportional punishment to his crime. Yes.
In those bifurcated trials, in the juries, are there any 16 or 17-year-olds in those juries?
No.
Okay, so how can you say this is fair when they're not, when the person is being tried and they're not being tried by their peers of their age group, and they're being judged by people who are older and have different views and aren't going to be as sympathetic to these kids who they're past their time. They're forgetting what it's like to be 16 or 17. How can you say that's fair to those people?
Well, in most cases, they're being tried as adults, so obviously they would have adults on their jury. They're being looked
But
at
they're
as
still
adults.
16, 17.
They're still 16, 17, but what they did goes well beyond 16 and 17. It's a crime that's so heinous that they must be tried in a sense of looking at them as they're older. They were mature enough to make this decision, and they're obviously mature enough to be judged by somebody older than them, over 18.
Mr. Kleckner, you just described the proportionality doctrine.
Yes.
Wouldn't you say that the evolving standards of decency doctrine takes precedence over the proportionality doctrine?
Well, I don't, as other co-counsels will talk about later, I don't think that the evolving standard of decency really has enough weight. As we said, 30% of the country, 30% of states still had juvenile death penalty. So 30% is still, although it's not a majority, it's still a large block of the country that have juvenile death penalty laws.
Mr. Kleckner, the evolving standards of decency doctrine takes into account not only the numbers of juvenile offenders that are put to death, but also the direction of change, the direction in which state legislature is going, and that's predominantly in the direction of eliminating the juvenile death.
It's predominant, but it's not an overwhelming majority. 30% is still a large number, a substantial number, enough where evolving standards of decency haven't gone completely in that direction. There are still enough states that maintain the juvenile death penalty that you can't outlaw altogether. And as we're saying here, this is not an everyday occurrence. This is, as we said, 22 executions in the last 37 years. There are only 22 by juvenile executions. It's a rare thing, and we're trying to keep it as a rarity, and by a case-by-case basis, it allows it to be a rarity. If you take in all the mitigating and aggravating circumstances, it should be a rarity, and it has been a rarity. It's not an abuse thing. It's not like we're killing hundreds of teenagers every year. These kids do a crime, and they deserve their punishment, and it's a very rare thing, and it should be maintained as that, and that's all we're trying to do. Yes.
Yesterday when the petitioners went, we spoke largely about the fact that so few states actually use the juvenile death penalty. Do you see that as a reason? So for that reason, should we change it, or do you see that the system that we have in place at the moment works well enough that it's not arbitrarily applied?
I think that it works well enough that it's not arbitrarily applied. If only a few states are using it, that's only a few states who think they should use it, and that's up to them. Right. So what defines a juvenile? It is certainly not a number. A juvenile is determined by their maturity, and being 18 does not determine how mature one is. There are plenty of 16-year-olds who are more mature than 18-year-olds or even 20-year-olds. You cannot establish a rule that makes 18 a sole determining factor in whether a juvenile gets the death penalty or not. It is way too arbitrary. Whether or not someone lives or dies should not be based just on age. All factors must be taken into account. So Kevin Sanford knowingly killed somebody. Although he was brought up in an awful situation, he still committed a crime and should be punished. His background did certainly affect his decisions, though. Kevin's background should have been discussed in his trial. We maintain that. If his circumstances would have been discussed, then maybe Kevin wouldn't have gotten a death penalty. Therefore, the opposition shouldn't be arguing against the death penalty, but more for a mistrial. that his background should have been brought up, and we know that these backgrounds should have been brought up, and that's the whole purpose of the bifurcated trial system. The court must use the totality of facts to determine the sentencing of a juvenile.